Thank you very much, Leon and David. All right, so to bring us kind of back full circle and to be our last intervention in our deep dive today is the one and only Jeff Rosen, who will reflect on questions like, does the internet allow us to be forgotten? And can we ever be private again?
Thank you so much. Well, ladies and gentlemen, we have heard an extraordinarily deep exploration of internet skepticism. And Kentaro has told us about the tyranny of acceleration. And Jonathan has talked about the tyranny of the algorithm. And Leon has talked so movingly about the tyranny of the acceleration of thought and emotion. And what I want to conduct with you is a debate about the central issue involving privacy and free speech on the internet today. Should there be a right to be forgotten? The Europeans have proposed such a right. Google is implementing it, and it poses the most dramatic clash between American notions of free speech and European notions of privacy in the 21st century. So I'm going to describe to you how the right operates. I'll tell you the best arguments on both sides, and then we'll have a debate about whether or not you would vote for this right to be adopted in America. And I'm going to do this in the spirit of the National Constitution Center, which I have the privilege to lead. This is a wonderful debate and education center in Philadelphia and around the web, which brings together the best arguments on all sides of the constitutional issues that transfix America so that citizens can make up their own mind. Okay, so here is the question involving the right to be forgotten. Let's begin with an American story, and that's the story of Stacy Snyder. This was a young woman who was a teacher in Pennsylvania a few years ago, and she posted a picture of herself on MySpace, this was a while ago, with a pirate hat and a plastic cup, and the caption was "Drunken Pirate." And her supervisors at the teacher training school that she worked at saw this picture and decided she was promoting underage drinking, and they fired her days before her graduation. She sued, invoking, in America, the First Amendment. She said, first of all, she wasn't doing anything illegal, and her speech should be protected by the Constitution. But a judge found that the speech didn't involve a matter of public concern, and therefore it was not protected by the First Amendment. And as a result, she never graduated from Teachers College and never got her degree and had to take an entirely different career. This woman's life was transformed by her inability to be forgotten on the internet. Now let's move to Europe. Just a few years ago, in a path-breaking decision, the European Court of Human Rights came to a very different conclusion. There was a suit involving a Spanish businessman called Mr. Costeja, and he objected that some truthful but embarrassing records of his bankruptcy, which had been written up in a Spanish newspaper about 10 years ago, were no longer relevant, and he wanted them taken down by the Spanish newspaper and non-indexable on Google. And a Spanish court, rather the highest court in the European Union, agreed with him and said, the Spanish newspaper doesn't have to take it down, but Google, because it's a search engine, does have to remove all references to this article because it's irrelevant or outdated and offended Costejas' dignity. And the European court then ordered Google and other search engines like Yahoo and Bing to take down any truthful but embarrassing information that any European citizen claims is outdated, irrelevant, or not in the public interest, or face fines of, in their initial version, up to 2% of their annual income, which in Google's case last year was $50 billion. This tends to concentrate the mind. Google initially said that they weren't going to comply, then they decided that they would comply, and ever since the decision went into effect, they've received 257,000 removal requests, and they have removed 40% of those requests and have refused to remove 60% of the requests. How does this right operate? Basically, if you're in Europe, let's say we were in Europe right now, someone may be tweeting that I'm giving a boring or overly earnest talk about the right to be forgotten. Right after the show, I could object that this offends my dignity, that this tweet is irrelevant or outdated or not in the public interest. I would write to Google, and then a series of lawyers at Google, who are led, as it happens, by a former student of mine, of whom I'm very proud, but he's working very hard right now, would have to decide, am I a public figure? Is the tweet in the public interest? Is it irrelevant or outdated? And would have to decide whether or not to remove the tweet. So These are very nuanced judgments. Google has tended to remove stuff that is embarrassing from private figures. It's left up stuff by public figures and politicians, but not always. The BBC has been required to take down a series of truthful but embarrassing posts about British politicians, and it's reposting those links. And essentially, it's a very big job for Google to decide what to take down and what to leave up. So let me just describe the arguments on both sides under American and European law, and then ask what you think. In America, this would clearly be protected speech under the First Amendment, because in a path-breaking series of decisions in the 1960s, the Supreme Court held that truthful but embarrassing information may not be removed unless it is intended to and likely to cause imminent violence. And that extremely rigorous standard, which makes us the most speech-protective country in the world, was taken from a beautiful opinion by my hero, Louis Brandeis. Whenever I have a hard question involving privacy or free speech, I ask, WWBD, what would Brandeis do? And in his beautiful opinion in the Whitney decision, Justice Brandeis said that because public discussion is a political duty, and because people can only develop their faculties if they have full access to information, it's up to citizens and not the government to decide what is in the public interest. In Europe, the law is very different. There's a strong tradition of protecting offenses against honor and dignity. If someone gives you the finger in Germany, you can sue for having your dignitary rights violated. Imagine how that would fare in California. This dignitary notion had been embraced in American law by none other than Justice Brandeis in an 1890 article about the right to privacy, where he lamented that the Kodak camera and the instant press were ensuring that what used to be whispered from the closets was shouted from the rooftops. But he changed his mind about that youthful article and came to believe that free speech was more important than dignity. All right, let's have a debate about this question. I want to start by taking a vote before, and then we'll have a discussion, and we'll vote after and see if anyone's mind was changed. If you were a member of Congress in the United States, would you vote to adopt the right to be forgotten as a matter of American law? Who would vote in favor of the right to be forgotten? And who would vote against it? Not everyone is voting, but I see a slight majority against the right to be forgotten, which very much reflects the American free speech tradition. Let's see if anyone's mind has changed after the discussion. Will someone who voted in favor of the right please make the case for why you think it should be adopted as a matter of American law? I'm a law professor. I can call on people. I want citizens to, you're going to end up, because this is going on in California, and Jim's going to tell us about it, but citizens of America, let's hear it. Yes, sir.
I grew up in Asia, so that might color my perspective on some of these things, but can you hear me?
Yes.
I feel that I am my own being, ultimately, and if I choose to be forgotten by all the bits and bytes that are out there, then I have the right to be forgotten. And I have the right to be left alone.
And how does your growing up in Asia affect that view?
We're not a very open society in some ways. And I think because we're not very open, we don't express a lot of things all the time. So the notion that everything that I express is always available to everybody else, it just seems very impersonal to me. It feels very naked.
That you've beautifully encapsulated this notion of reticence and dignity. And it is the case that Asian societies and European societies, which have traditionally been far more hierarchical, so people know their place and they know how to behave, are not as exhibitionistic and open, and believe that it is an indignity to be exposed against your will, that you really should have a right and a duty to control your reputation, and it's therefore makes sense that you might think that that right should be enforced on the internet. So thanks for that. All right, from the other side, the American perspective, well, let's have more on the dignitary right. Echo it. Great.
I voted the other way, but I'm a lawyer, so I'll give you something to use.
Good.
And that is that the freedom of speech is found to include the freedom to not speak. So we might try to draw a parallel between the right that people have to post things on Facebook includes my right to not have things posted.
That is a wonderful insight. My right to define myself can include the right to speak or not speak. The right to anonymity, the Supreme Court has told us in a series of recent decisions, is crucial to political dissent. And you think that if Stacey Snider put up her picture, she should have the right to take it down. Now this becomes complicated. What happens if Stacey Snider puts up her picture and then it goes viral, as it did? And then it's on lots of other websites, millions of them. This happened in Argentina when a pop star posed for racy pictures of herself and then ran for parliament, as pop stars in Argentina and Italy seem to do. So she then sued and said that these racy pictures should come down as an offense against her dignity. Yahoo initially said no, and an Argentinian court ordered Yahoo to take it down with fining them $10,000 a day. So they then removed all reference to this woman from the search engine. If you put in her name now to Yahoo Argentina, you get a blank page and a judicial order. Basically, she removed herself from public discourse. Is your view different when the picture is widely shared than when someone just posts it themselves?
Well, actually, I don't hold the view. But I would say if you're going to be a purist about it, I think you have to pick one or the other, and that the amount of disclosure isn't relevant.
That is, I like the purity and also the fact that you're arguing it round and flat, and that is what the Europeans have held. They say that you can take down not just stuff I post myself, not only stuff that I post myself that's widely shared, but also truthful but embarrassing stuff that other people post about me, like that completely scurrilous tweet that someone may be thinking of sending, saying that this is not a riveting presentation. So I'm glad you're living by your principles. Yes?
I think it's a tough question, but at some level, doesn't this have the potential to become a bit of a slippery slope? Because, I mean, these are search engines, and we use them primarily, in spite of all the potential for bias and everything else, to get information, to make decisions. And if either the companies or the governments or the courts are empowered to decide what information you actually have access to, when does that stop being about dignity and start being about controlling the information, right? When a country decides that Google has to block the Israeli National Museum's archive that's now digitally online because they disagree with the Israeli country politically, how far is this from that?
That is that central question, and it's a constitutional question. Who should ultimately decide what is fit for public discourse? And the American response had been the people decide, and the government has no business second-guessing that choice. The Europeans have now said the search engines have to decide, and they're delegating to American lawyers the duty of channeling European values, and that could indeed be manipulated for political reasons. That's a good practical objection to this right. We have 2 minutes. Jim, tell us briefly what California is doing and how it's adopted a right to be forgotten for kids.
So we passed a law a year ago called the eraser button law, but it applies to everybody under the age of 18. So we believe that the right to be forgotten should exist for people under the age of 18 because they do a lot of stupid things. Adults do as well. But we feel, and we passed it over the objection of major lobbying from Google, Facebook, and most of the other internet players, which we did in the same, then earlier this year we passed a student privacy law, also over the objection of virtually all the major internet companies in the United States, who I feel are shamelessly protecting their own personal privacy, but ignoring the personal privacy of my kids and your kids and other people. So we passed it. There has been no legal challenge to date, and we're looking to actually franchise that law at the state level around the country. There's no chance it'll pass at the federal level because of the power of the tech industry to block legislation in Washington. But it is essentially the right for young people under the age of 18. You can go to Google, you can go to Facebook, go to any platform and have it taken down. And you can also, in certain cases, remove viral efforts. And there's been no legal challenge to it. And quite frankly, the tech companies went to pass, stepped back, and agreed it was fine for people under the age of 18.
Fascinating example. California protects privacy far more than any other state. It has a state constitutional protection for privacy, and the question of whether this is consistent with the First Amendment may indeed be tested before the courts. Google is being challenged on First Amendment grounds on lots of scores, and has fought back by claiming that everything it does in its algorithm is protected First Amendment speech, and to second guess the algorithm is an offense against Google's First Amendment rights. So it might push back and say in the US, we can't be told what to take down because our algorithm is a form of corporate speech. but it's a great example of what Americans are doing. One final comment, I think, and then we will vote. Yes, sir.
I abstained from voting because the either-or, positive questions either-or seems so questionable. For example, you talk about American and international and online and modern and ancient values. And the internet being so famously free, and really I'm not an expert on this, and algorithms is fascinating. But somehow Google wanted to have business in China, so they let the Chinese government censor Google. So I think this is just a frontier that is being fought out like the manifest destiny coming to the West. Step by step, and not all or nothing.
It is indeed a frontier. The deepest constitutional questions of when Google goes into a country like China, or Facebook, which is considering going into China, whether it will reveal the data of dissidents and, or whether it will protect American values, is central. And you're right that nuance is helpful here. But although nuance is helpful, we have to vote, as at the end of every constitutional debate. So we're going to take a new vote, and then I'm going to ask anyone if they change their mind. After this good discussion, who would vote in favor in the US of a right to be forgotten? And who would vote against it? And how many people changed their mind? And did you go from yes to no or no to yes?
I went from abstain to support.
Abstain to support, and you, sir?
I went to yes. I would like to be forgotten.
Good. Well, with that good spirit, I think we all would, but no one would like to forget this really riveting debate. As Kitty said, these deep dives are an experiment. They're trying to bring together an unusual combination of really deep thinkers, and I think this has been a tremendous success. Thank you so much, ladies and gentlemen.